Good morning, everybody. I'd like to open this Polk County Board of Commissioners meeting. It's January 3rd. All commissioners are present. Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. And next up, looking for comments, not on this agenda. Hearing none. Brings us to Polk County District Attorney update, Mr. Aaron Felton.
Commissioners,
Morning.
very happy new year. Privileged to be on the first agenda of 2023 and talk about briefly, and probably not go into great depth, but at least kind of give you an overview of some of the main issues which we're looking at in my office and perhaps sort of statewide from an ODA's perspective. But 2023 always brings a spate of new laws into effect that the legislature passed. And this year, there's not a ton in terms of criminal justice issues. I think there's probably more civil issues if you yourself have taken a look at what's going into effect. But I would say notably in terms of my office from a practical effect, the restitution legislation, the update to the restitution laws finally is going into effect, effective January 1. And from my office's perspective, what has been improved upon in the new legislation is the way we're able to prove restitution for crime victims. One of the things that happened due to a couple of opinions coming out of the Court of Appeals is that it made it much more challenging for prosecutors after a conviction was obtained. If a defendant wanted to contest the amount of restitution, especially in a case involving injury, we were required to prove the amount of damages by bringing in medical professionals or other folks that require a hearing and other elements of proof, which are very challenging for us to bring those folks in to provide testimony as to the nature of damages. The legislature looked at that after hearing a lot of testimony from involved folks, changed the statute so that in order for us to be able to prove damages, simply bringing in bills, medical bills, testimony that would be now sufficient if they were provable and satisfactory in terms of evidentiary quality. So that was a very significant change, allowing us to go forward in proving those amounts of damages, injury, and costs in terms of recovery for victims. So that was very significant. And we've had a lot of hearings since the legislation was actually passed in one of the earlier sessions. Going, oh, January 1st come. I think that's a great victory, not only for practitioners, but also victims as well. So that, from our perspective, is a significant change to the law that went into effect today. So that I can announce with to the commission. So the court is also aware, late last week, the Supreme Court did issue another ruling related to the unanimous jury verdicts. Ramos, we call everything the Ramos related rulings. It's not even called, the cases different names, but Ramos related rulings. They do have essentially deal with the requirement that in felony cases you must have a unanimous jury verdict finding them guilty in felony cases. It's always been true for murder cases in the state, but as the court's aware, it was not the case in other felony cases, sex abuse and other types of felonies. The Supreme Court a couple years back in a case called Ramos said that was unconstitutional. There's been a lot of legislation, a lot of conversation about that. ODA, I spoke at hearing a couple years back in favor of changing the law to make everything unanimous going forward. Really, the great controversy has been, does that apply retroactively? Well, the Supreme Court essentially said it applies retroactively regardless. No question about it. There's no, all confusion aside, it is retroactive. And We have dealt with some of those cases. We knew some of those cases were happening in terms of the appeals that were online. And so we have dealt with those in different ways. We have settled some of those cases. I'm really coming today because that opinion came out really last business day of the year, essentially. I can't say today how many cases are potentially impacted in terms of Polk County folks. So we're looking at that. I can say that even one case that traumatizes a victim and their families is challenging for us. And I'm not going to stand here and pound the pulpit. I just know as a practitioner, in terms of our victims advocates, in terms of families affected, that's going to be very, very challenging. And that's tough. That's going to be tough going forward. It's also if we have to try older cases. We've had these conversations before in terms of our resource and ability to do that. Makes us have to make some very tough choices going ahead. We're a county not like Washington or Multnomah County, where the numbers are probably much greater. Nonetheless, we have families that may be impacted by that, and I can have more conversation going forward. But regardless of how anyone feels about the impact and the principles behind it, which I at some level I support, I understand, but I understand from a day-to-day practical level, this will have great impact on people. And so I will leave it at that. So that happened. And finally, we are heading into a new legislative session. ODA will have a package of proactive policy bills which deal a variety of areas we're dealing, which I will send to you offline so you can see the package itself and look at them. I don't want to take time delving into the weeds of the individual policies. We have policies dealing with sort of the mundane all the way from clarifying what are court certified copies. Can we take them offline rather than having to go to individual counties seeking court certified copies of convictions, which will make things much easier for us dealing with how we're addressing the fentanyl epidemic in this state. We have a bill on that, all the way dealing with some of the issues that we've talked about, the attraction and retention of deputy DAs in terms of compensation. I know at AOC, there's going to be a presentation from some folks from our board. Will be coming to AOC, your board, to talk about the bill we have in terms of including deputy DAs in the PERS for police and fire. There will be a presentation on that to AOC's leadership, I believe on the 6th that is scheduled. So you'll be able to hear about that. And also some other equality-based pay issues. We're making a pitch to include pay increases for deputy DAs, elected DAs, along with judges and other public safety personnel this year. We believe that all public safety folks, including public defenders, prosecutors, judges, ought to be considered in terms of equitable compensation. So that is a rough overview of what's going on from the prosecution world right now. So as always, I'm available for questions from commissioners.
I have a question on
Yes,
the retroactive nature of the non-unanimous juries, the pain and suffering from families and victims notwithstanding. I'm just curious that there was some talk that data may not even be available, whether or not a jury was unanimous or not. Can you talk a little bit more about some of the administrative challenges?
Let me try to answer as best I can, because when the data not being available could mean, and I hope I answer your question from where you're asking it from, because it's impossible to know. Every single jury verdict is not always polled. When I say polling, we don't always know whether the juries were unanimous or not, because when a jury renders a verdict, the verdict form always comes back guilty, not guilty. It doesn't have a number of votes one way or another. Now, at the end of every trial, the court asks prosecution defense, would you like the jury polled? And that is up to each individual side. And not every verdict, not every jury is always polled. So it is simply not known for some juries whether, because a poll wasn't taken of the votes, whether or not they're unanimous or not. So some jury convictions simply go down without any knowledge of whether that jury was unanimous or not. So it simply is impossible to know. So for some juries which were polled and came back not unanimous, there is a known result on the record. Only those can be really part of any sort of appeal based on non-unanimous. So yeah, you're absolutely right. It's an unknown quantity. And some defense attorneys asked for that, some didn't. So yeah, it is. So, but the exact number at this point is unknown. If you had a total universe of every single jury verdict that came back, if there was a legal requirement, all juries had to be pulled, we would have the defined universe at this point. Yeah, there are unknowns.
Thank you.
Good question, Don. Very relevant to this topic. So, not seeing any more at this point. So again, thank you for the opportunity to appear.
Thank you. Thank you. Non-listed items for today. Hearing none, we're adjourned.